All righty. Okay, we are going to go ahead and begin our fair housing panel discussion. I want to go ahead and thank everybody who is currently online with us, as well as our 4 presenters we have today. Go ahead and introduce myself. My name is Mackenzie Holden. I'm with the Indiana Civil Rights Commission as the communication manager, and I'm going to be moderating the panel discussion this afternoon. I want to thank everyone who is already online, and just let everyone know that this entire panel discussion will be recorded and it will be available for future viewing and sharing on our website about a couple hours after the session ends. I will post that link into the chat on the right so that everyone can access that as well. Let's see, this is our third, ICRC's third virtual fair housing webinar in the past year. And we are pleased to have a couple new amazing presenters from HUD and IHCDA today to share some pretty insightful and helpful information for you all. We have the U.S. Department of Housing and Urban Development's Regional Director Lon Meltesen to give us a HUD overview, as well as share a little bit about ICRC and HUD's partnership. We also have IHCDA, which is the Indiana Housing and Community Development Authority's Director of Real Estate Compliance, Ms. Devin Smith, and she's going to be giving everyone some available resources that are currently offered to Hoosiers. We also have ICRC's Director of REPACE, which is our Real Estate Public Accommodation and Education Department, Melissa Deering. She's going to give a housing overview. And then we have our Deputy Director of the Civil Rights Commission, Tim Schultz, who's going to give us some legal information as it relates to the fair housing. During the presentations, I do want to welcome any and all comments in our Q&A session, or our Q&A box on the side. If you go up to the top of the screen, you'll see a little bubble with a question mark. That will activate the Q&A, and you're able to put any questions in there. You can put your name in there, or you can submit it anonymously. We are going to be reviewing all of the Q&As that come throughout the presentation, but at the very end is when we will do our Q&A session, and I will start at the very top and work my way down through all of the questions, and we will get all of your questions answered at the conclusion of the presentation. So I want to go ahead and turn it over to ICRC's Executive Director, Greg Wilson. He's going to give a couple of welcoming remarks before we begin our panel discussion. So Greg, go right on ahead.
Thanks, Mackenzie. Again, I want to thank everybody for participating in today's ICRC Fair Housing Virtual Panel Discussion. Fair Housing Month is very important. You'll hear a lot of information that we'll push out during this month talking about fair housing. And we just want you to know here at ICRC that we're here if you need help or assistance, feel like you're being discriminated against when it comes to fair housing, please call us or go to our website, and you can communicate with us your situation, and we'll do all we can to assist and help you. But I want to also thank all those that are participating on the panel. I want to thank for sure our regional HUD regional director, Lon Meltesen. I mean, we really appreciate, this is the first time we've ever had this happen with us doing one of our fair housing panels. So thank you, Lon, so much for being a part of this program. And again, always our partner at ICDA, Devin Smith. We really appreciate all that you do to support us there at ICDA. So thank you. I appreciate everybody watch. If you have questions, feel free to ask, and I'll let us go ahead and move on with the panel discussion, Mackenzie. Thank you.
Yes, thank you so much, Greg. With that, we are going to go ahead and begin our presentation with Mr. Lon Meltesen from HUD.
All right, thank you, Mackenzie. So as Director Wilson indicated, my name is Lon Meltesen. I'm the Regional Director for the Office of Fair Housing and Equal Opportunity at the U.S. Department of Housing and Urban Development for Region 5. And what I'd like to do today is to first give a little introduction about Fair Housing Month. In April is considered Fair Housing Month. So I want to talk a little bit about what that means for us at HUD. And then I would like to give a short overview of the Office of Fair Housing and Equal Opportunity here at HUD to give you an idea as to what roles we play in fair housing at HUD. And then, since the Indiana Civil Rights Commission is a Fap agency with HUD. I would like to talk a little bit about our Fap program at HUD and our partnership with agencies such as ICRC. And then finally, I want to conclude with going over a few of our fair housing priorities that we have at HUD and that we share with the new administration. So with that, I would like to begin by saying that every April we commemorate the Fair Housing Act, the landmark civil rights law that was enacted in 1968. The purpose of the act was to bring an end to discrimination in housing and to eliminate the patterns of racial and ethnic segregation and economic disparities that have long existed in our neighborhoods and communities across the United States. It is time that we make sure that the Fair Housing Act is more than just words, but translates into real actions that result in greater equity for all. We must work together to make the purpose of the Fair Housing Act a reality. This year, we are celebrating the 53rd anniversary of the Fair Housing Act at a time of unprecedented challenges, a time when we are recovering from a pandemic that has killed over 500,000 people in the United States. And this year's Fair Housing Month's theme of fair housing, more than just words, is so relevant and timely and reflects the need for action. The theme is consistent with the approach that the Biden administration is taking towards advancing equity in housing and the importance of increasing the public's awareness of their housing and civil rights. I would like to thank Director Wilson and the Indiana Civil Rights Commission for inviting me here today and allowing me to speak a little bit about the Office of Fair Housing and Equal Opportunity. With that, I would like to give just a kind of general overview of the Office of Fair Housing and Equal Opportunity here at HUD. First, as I had indicated before, I oversee the FHEO for Region 5. Region 5 is one of 10 regions in the country, and it includes the 6 states of the upper Midwest, which includes Minnesota, Wisconsin, Illinois, Indiana, Ohio, and Michigan. Our mission at FHEO is to create equal housing opportunities for all persons in America by administering laws that prohibit discrimination in housing on the basis of race, sex, color, religion, disability, familial status, and national origin. So what are the laws that we enforce in the Office of Fair Housing and Equal Opportunity? Well, the first major law we enforce is the Fair Housing Act, which is also referred to as Title VIII of the Civil Rights Act. And this law prohibits housing discrimination throughout the country and includes both public and private housing. In addition to the Fair Housing Act, we enforce Title VI of the Civil Rights Act of 1964. And that statute prohibits discrimination in the activities and programs that are funded or that receive federal financial assistance from the federal government. We also enforce Section 504 of the Rehabilitation Act of 1973. And this prohibits discrimination on the basis of disability for activities and programs that receive federal financial assistance and requires those activities and programs to be accessible to persons with disabilities. Additionally, we enforce Section 109 of Title I of the Housing and Community Development Act, which prohibits discrimination in programs and activities that are funded by community block grants and other similar assistance. So here in the Office of Fair Housing and Equal Opportunity, we have 2 major functions. Our first function is to enforce the Fair Housing Act, and our second major function is to monitor all of HUD's programs and recipients of HUD's funding to make sure that they're in compliance with the civil rights statutes. So that's kind of an overview of what we do in my office. The Office of Fair Housing and Equal Opportunity is just one of several offices in HUD. We are small in terms of the number of employees, but large in terms of the mandate of our mission. Now I'd like to talk a little bit about our Fair Housing Assistance Program. So under our Fair Housing Assistance Program, the department enters into cooperative agreements with state or local government entities if they enforce a law which is substantially similar to the Fair Housing Act. So what does it mean to be substantially equivalent to the Fair Housing Act? Well, in order for a Fap agency's law to be substantially equivalent, it must be substantially equivalent in 4 major areas. And the first major area is the substantive rights protected by the law. And so what we mean by this is that the various bases that are protected in the state or local law must include all 7 of the bases that I previously referenced, such as race, color, disability, etc. In addition, the state or local law must also include the same overall protections in terms of what is prohibited by the statute. So it must prohibit discrimination in rentals and sales and lending, and it must afford persons with disabilities the rights to reasonable accommodations and modifications along those lines. So the law must be substantively equivalent to the Fair Housing Act. But in addition to that, it must be substantially equivalent in the procedural process. And what we mean by that is that it must be similar to the process for the intake of the complaint, for the investigation of the complaint, and then if there's a cause finding, for the litigation of that cause finding. So the process that complaint is handled must be substantially equivalent to the process that's set forth in the Fair Housing Act. And it can't have any additional barriers or other requirements that could limit a person's ability to go through that administrative process. In addition to being substantially similar in the rights and in the procedures, it also has to be substantially similar in the remedies that the state or local law provides for. And so that's in terms of the relief that's available for a victim of discrimination. And then finally, in the 4th area where it must be substantially equivalent in is the availability of judicial review, which is the ability for the person to go into the circuit courts if they want to litigate their claim there and to seek judicial review of their claim of discrimination. So now the Fap program was included as part of the Fair Housing Act because Congress had the insight to realize that HUD, or the federal government by itself, didn't have the ability or the resources to eliminate discrimination on its own, and that it needed the help of its state and local partners, like the Indiana Commission on Civil Rights. And I've been a firm believer that in order to conquer this tough issue of discrimination in housing, it's going to take not just the federal government's efforts, but the federal government working with state and local governments towards a common mission of eliminating discrimination in housing. Now, if a Fap agency's law is substantially equivalent, they can then become a member of our Fap program. And when that happens, then HUD is able to then refer complaints that are filed with us that are within the jurisdiction of the state or local Fap agency. All right, so under our Fap program, in our region, we have 14 Fap agencies. So we have 4 state Faps and 10 local Faps. So our 4 state Faps are the Illinois Department of Human Rights, the Indiana Civil Rights Commission, the Ohio Civil Rights Commission, and the Michigan Department of Civil Rights. In addition to those 4 state Faps, we have 10 local Faps. So we have in the state of Minnesota, the city of St. Paul. In the state of Indiana, we have the cities of Hammond, Fort Wayne, Evansville, Gary, Elkhart, and South Bend. And in the state of Ohio, we have the cities of Canton, Dayton, and Shaker Heights. Now, last year alone, HUD and its Fair Housing Assistance Program partners received over 7,700 complaints alleging discrimination based on one of the protected classes of the Fair Housing Act. In addition, in our region alone, our Fap state and local partners completed 1,117 cases, of which 134 resulted in a probable cause finding of discrimination, and over 250 of those cases were resolved through a settlement, either through a conciliation agreement or a private settlement through the parties. So as you can see, a large part of the work that we do in fair housing is done by our Fap partners. So we are very fortunate to have agencies such as the Indiana Civil Rights Commission who can help us with this common mission of eliminating discrimination in housing across our country. In addition to providing support for the investigation of cases, last year, HUD awarded $1.5 million in partnership and special enforcement funds through the CARES Act to our FAP partners to support COVID-19 education activities and also to provide technical and equipment support for FAP agencies so that they could continue to accomplish their mission through the pandemic conditions. So now that I've talked a little bit about our FAP program, I want to conclude with spending a few minutes talking about some of our fair housing priorities here at HUD and with the new administration. So central to HUD's mission is to promote fair housing and rid the nation of housing discrimination and overcome the lack of fairness created by decades of systemic inequitable policies. As a nation, we're finally confronting some of the most difficult issues that have persisted for far too long, and HUD, as well as the new administration, is working tirelessly to promote and to vigorously fight for the rights of underserved communities. And I would like to highlight three particular areas which are very important to HUD and to the new administration. And those are: first, advancing racial equity; second, eliminating barriers to opportunities and benefits in federal programs for people of color and other underserved groups; and third, protecting against discrimination on the basis of sexual orientation and gender identity. The administration has already demonstrated its commitment to these issues, and HUD has begun to implement many of the President's executive actions. First, on January 20th of this year, President Biden issued an executive order on advancing racial equity and support for underserved communities. On day one, this administration began the work and demonstrated its commitment to working with communities to end housing discrimination, redress the ongoing harms of racist housing policies, to remove barriers and restrict access to housing and neighborhood choice, and to secure equal access to housing opportunities for all of us. Second, the President has ordered HUD to determine how to redress our nation's and the federal government's history of discriminatory housing practices and policies, and we're working on doing just that. But this is going to require us to work together with our stakeholders, who will play a critical role in ensuring that we are undertaking and meeting this challenge. And then third, President Biden, on his very first day in office, made clear that this administration will prevent and combat discrimination on the basis of gender identity and sexual orientation. We are proud that HUD was the first federal agency to implement the President's executive order on this topic. On February 11th, HUD issued a memorandum stating that the Bostock Supreme Court decision extends to the Fair Housing Act's prohibition on discrimination because of sex. So some of you may have recalled that last year, the United States Supreme Court held in the case of Bostock versus Clayton County that under Title VII, which is the federal anti-discrimination statute for employment, that the language in that law, which prohibited discrimination based on sex, also discriminated discrimination based on sexual orientation and gender identity. So HUD has reviewed the language of the Fair Housing Act and has determined that that language is substantially similar to the language in Title VII, and therefore the Fair Housing Act should receive the same interpretation as Title VII. So we are proud to say that HUD is interpreting the Fair Housing Act as prohibiting sexual orientation and gender identity as a form of discrimination based on sex. So before I conclude, I just want to let everyone know that if you believe that you have experienced discrimination related to housing, or if you know someone who has, You can file a complaint by contacting HUD's Office of Fair Housing and Equal Opportunity at 1-800-669-9777 or visit our website, and you could file a complaint online through our website. I want to emphasize that during the pandemic, our doors are still open and we're conducting business as usual. We're not in the actual office, so we're all working remotely, but we're continuing to intake complaints, we're continuing to investigate complaints, and we're continuing to enforce findings where we do find that there's evidence of discrimination. So if you have suffered any kind of discrimination, I encourage you to file a complaint either with us or with our FAP partners like the Indiana Civil Rights Commission. So that concludes my presentation. So once again, I want to thank everyone who are participating in the event today for allowing me to give you a brief overview of the Office of Fair Housing and Equal Opportunity, and to our FAP partner in the Indiana Civil Rights Commission for giving me this opportunity.
Thank you so much, Lon. We appreciate you. And with that, we will go ahead and turn it over to Devin Smith with IHCDA to give available resources as well.
Okay, thank you so much, Mackenzie. I'd like to state thank you for inviting me to participate in this panel discussion. And thank you to Greg and your team for allowing us to discuss the housing resources that Indiana has to offer. Our mission is to create housing opportunities as well as to strengthen communities and to promote self-sufficiency. So hopefully after I go through these slides to discuss the housing opportunities that we have currently within our agency, that it will help someone in need. I'd like to discuss first the Indiana Emergency Rental Assistance Program. This is our second phase of this program. Last year, we offered this program. We received about $45 million where we distributed up to $2,000 of rental assistance to individuals who are financially impacted by the pandemic and who are unable to make rental assistance payments so that they can reside in their home. This year, we have received 10 times that amount, so a little over $451 million. And the difference between the first phase and the second one is that we are allowed to provide up to 12 months of assistance for past due rent, including any late fees, as well as any ongoing rental assistance. The other difference between the first phase and the second phase is that tenants may receive direct payments if the landlord refuses to participate. We had noted in our first phase that there were many landlords across the state that were unwilling for whatever reason to participate in the program. In that original program, your landlord had to be on board with the program. So we have made this change so that we can ensure that we are reaching all households who are in need. There is an established limit or cap as to how much assistance that we are going to provide on a monthly basis. So depending on how much an individual's rent is, we may be able to cover the full amount or a partial amount. And the landlord, or the tenant, would be responsible for the additional amount. So in order to visit and learn more about this program, I always have at the bottom of the screen the website. This website not only has resources for the tenant, but also the landlord, and there's a link there to apply for the program. This program is currently in the works, so they have a really good turnaround time to assist those in a timely manner. There are some exclusions to this particular program, and the first one is that residents who reside in Elkhart, Hamilton, Lake, Marion, and St. Joseph counties, along with the city of Fort Wayne, are excluded from applying for IHCDA's ERA program. And the reason is because these entities are offering or administering their own version of this program. So one of the items, the exclusions, is that you cannot double dip. So if you're receiving assistance or if your local municipality is offering this program, then we encourage you to apply with them. The other exclusion is for individuals who are already receiving rental assistance, such as those who are a current beneficiary of the Housing Choice or Section 8 voucher. Since they are already receiving that type of rental assistance to help cover a portion of their rent, we are also unable to help those individuals. So as I mentioned before, this particular program will allow for us to pay for past due rent, late fees, and any ongoing rent for up to 12 months. But what it cannot pay for are legal fees, pet fees, or deposits. This particular program also excludes any utility payments that are included in the lease. We do have some assistance for utilities, and I'll mention that in the next slide. The element of the Emergency Rental Assistance Program also includes utility assistance. Again, these are utility assistance that's not listed in the current lease. We will provide up to 12 months of utility and/or home energy assistance for past due expenses. And this particular coverage will go from April 1st of 2020 through the date of the application. There may also be a $750 one-time benefit to those who have exhausted any additional home energy assistance that they are already currently receiving. Again, at the bottom of the screen, there is a direct link to more information about this particular program, as well as a way to apply. Again, there are some program exclusions for this particular part of the ERA program. As I mentioned before, there are some local municipalities that are offering a similar program. So we encourage those who live within these areas to apply through their local municipality. The ERA program is not able to pay for any deposits for utilities to set up or to reconnect or disconnect. So they are encouraged to work directly with the utility company to make a payment arrangement in order to avoid disconnect. So I also wanted to talk about there are current beneficiaries of the LIHEAP program, which I will mention in a few moments. So this is just quickly, this is an assistance program to help individuals with heating specifically in the winter time. And so this is an assistance type, but individuals who are beneficiaries of that program are also able to, they are eligible for this particular assistance. And lastly, which is really exciting, is the internet assistance, which is something that we have never done before across any of the 43 programs that we currently offer at Indiana Housing Community Development. This is offering through ERA, we are able to offer up to 12 months of internet assistance. And this is for any past due expenses as well, from April 1st, 2020 through the date that they apply for the program. All that you need to do to be eligible is to have at least one child of school age from ages 5 to 18, or be able to, you have worked from home for at least 20 hours a week, you're currently on unemployment benefits, or that you have an insurance that allows for these telemed, telehealth, or teledoc services. Again, at the very bottom of the screen, there's an opportunity for you to apply for the program and to get more detailed information. Again, with the program exclusions, obviously those, and I've mentioned this twice now, but those who are local to municipalities that offer the program are not eligible for Indiana Housing's ERA program for this particular internet assistance, but they are encouraged to apply through their local municipality. It also does not pay for any deposits, reconnect, or disconnect fees as well. The next thing that I would like to talk about is the LIHEAP program. This is not a COVID-specific program that was created, but I thought it would be a good opportunity to discuss it anyway, because it assists individuals with their energy, paying for their energy bills. So this is a program that's been a long time program within our portfolio, but typically we have the same individuals who apply over and over again. So I thought this would be a good opportunity to speak with you about it so that we can help as many people as possible. We are currently offering applications. The application phase actually began in November, and it runs, we are accepting applications through May 14, 2021. For those who applied earlier last year, or later last year rather, there was a moratorium that was put in place, which essentially does not allow your utility company to disconnect your services. But that since has ended on March 31st. So I didn't put it in the slide, but just kind of mentioning if you want to apply for future years, that there's a benefit there. There are income eligibility requirements, and if you click the link below, it will provide you with the actual 60% set aside, the 60% rent limit for those, since it's an affordable housing program. So that's all of the programs, well, some of the programs for rental assistance. I'd like to also kind of transition into those who are homeowners who are struggling to pay for their mortgage. This is a program that we have had for quite some time, but we have stopped taking applications because we're kind of winding down with the program. This Indiana Foreclosure Prevention Network program assists homeowners with rental assistance up to $30,000 or up to 6 months worth of assistance. These are for individuals who are unable to make mortgage payments due to some sort of involuntary financial hardship. So the reason why we started to take applications again is obviously because of COVID, and there were so many people who were financially impacted by that. We are currently accepting applications, and the end application date is May 3rd, 2021. For more information, and there's a lot of information that needs to be provided in order for someone to benefit from this particular program. So I would encourage you to reach out, click on the link below at 877-GET-HOPE. You will be partnered with an individual who works all day in this particular area. And they also will work with your mortgage lender as well. So there are some resources that I wanted to discuss, as there are times when IHCDA is not able to help, and that is because that is outside of our legal authority to intervene. But we never want to leave a particular tenant or homeowner hanging. So we do provide resources, contact resources to get some additional assistance. The first is the tenant rights, laws, and protections. We have realized that over the years, or since I've been here, I've realized over the years that many tenants do not either read the lease that they have signed, nor do they know what their tenant rights are. So we've provided a resource for you so that you can be aware of what your rights are as a tenant. As always, we partner with the Indiana Civil Rights Commission. Anytime that we receive a call or a complaint from a constituent who has stated that they feel like they are discriminated against in one way or another, we are always in communication with the Indiana Civil Rights Commission, who is the legal authority for Indiana to intervene and investigate in those particular situations. Because a lot of our programs have a lot of criteria that need to be met in order to qualify, sometimes we are not able to help an individual. So we will direct them to call their 211, which is a local resource that will pair you with an agency that will provide, or at least look for local resources that are available to help assist someone. We did receive quite a bit of feedback from tenants, as I mentioned before, with the ERA program, our first phase, where landlords would not participate, or they would just evict somebody without probable cause, essentially. So we'd always like to provide a low cost to free legal services. So there's a number for that, as well as the Attorney General Consumer Protection Division. So this particular division handles a lot of complaints that are outside of IHCDA's authority. So that ends my presentation today. If there are any questions that you have regarding the programs that are discussed today, as well as any of the other 43 programs that we have, I've provided our contact information and we'd be happy to help.
Thank you so much, Devin. And with that, we're going to go ahead and turn it over to ICRC's REPACE Director, Melissa Deering.
Good afternoon, and again, thank you for joining us today. As Mackenzie stated, my name is Melissa Deering, and I am the Program Director for the REPACE Unit at the Indiana Civil Rights Commission. Today, I'm going to be providing the Indiana Civil Rights Commission's jurisdiction, and will also be providing an overview of the investigative process for fair housing complaints. Before I get started, I do want to point out a disclaimer that the Indiana Civil Rights Commission does not make the laws, we just enforce them. This presentation is not intended to be legal advice. For legal advice, please contact an attorney. And also, this information provided is not considered as Indiana Civil Rights Commission's policies. So what laws give the Indiana Civil Rights Commission the authority to investigate fair housing complaints? Indiana Code 22-9 and the Indiana Fair Housing Act, Indiana Code 22-9.5. Under this jurisdiction, the Indiana Civil Rights Commission has this jurisdiction extends to individuals, private or public entities, housing providers, and business establishments within the state of Indiana. The Indiana Civil Rights mission is to conduct a neutral and thorough investigation of complaints in order to eliminate discrimination based on protected classes that are enforced by the Fair Housing Law. We also provide education and outreach resources to the public. Okay, under the Fair Housing Act, there are several bases that are covered as far as an investigation. Those bases include race, religion, color, sex, disability, national origin, ancestry, and familial status. There are a couple additional bases that are covered under other statutes that are enforced by the Commission, which are covered under the employment discrimination laws. Here at the Indiana Civil Rights Commission, there are 5 specific areas that we provide enforcement for complaints filed with our agency. The first one would be housing and real estate transactions. Those can include commercial properties under the civil rights law, which would be buildings that are rented out for the purposes of commercial renting. We also have areas that we cover in employment, public accommodation, education, and credit. So there you can see why we are called the REPACE unit, because we basically investigate all those complaints except the employment complaints. Okay, in filing a complaint, you can, it starts at the intake process, and we'll talk about that, how to file a complaint in a couple slides after this one here. So you start with the intake process, and then once we receive a signed complaint, then it goes through the investigative process, and where the case is investigated. We'll also talk in more detail about what that investigative process looks like a few slides down. And then we have a litigation process that takes place in front of an AOJ, or the parties can elect to go to state court to have the case heard in front of a judge. Okay, an individual can file a complaint by calling the agency, by coming into our office to file a complaint with one of our intake specialists. Due to COVID, we had not been taking any walk-ins. However, We have started that process again where you can walk into our agency to file a complaint. You can also file a complaint online, and a written complaint or a complaint will be mailed to you for your signature. For fair housing complaints, those complaints must be filed within 1 year of the actual discriminatory act. And then for all other complaints, if it's under the Civil Rights Act, you have 180 days to file that complaint, and we will process your complaint once we get a signed complaint. So now I'm going to talk about the investigative process. A lot of outside parties don't know the steps that go into conducting an investigation on fair housing complaints, or any complaint that we take in the agency. And we do, like I said, conduct thorough and neutral investigations. So sometimes that means gathering a lot of information and making determinations based on that information. So the first thing we do basically in conducting our investigation is, like I said, obtain that information, basically concerning the events or transactions that relate to the alleged discriminatory housing practice that are identified in the complaint itself. So we review the complaint to see what our jurisdiction is and make sure that we gather information as it regards to that complaint. Once we get all that information, we do have to make sure that we are documenting this information, which would be witness statements, any policies that respondent may have, any practices that they deviate basically from the policy that they have. And all this information has to be documented. As Lon mentioned, we have a partnership with HUD, and so there's information that has to be documented into the HIM system. So we document that information there, as well as in the file. So there's, it's pretty much documented at least 3 places within our agency in order for us to have that information. And then we actually have to make a determination as to whether the evidence we have gathered supports a cause decision that a discriminatory practice has occurred or is about to occur. So in housing, that's a little bit different because it could have actually occurred, or if the complainant feels like it is possibility that it is something that may be coming down the line. And then we also have pitfalls that we run into when we are dealing with complaints. Sometimes we have respondents that don't want to fully cooperate with the investigation, and so they don't provide documentation we need. They don't provide the supporting documentation to support their position or, their explanation as to what happened. They're not willing to discuss with us anything about the complaint, don't want to provide any information. So sometimes this can be difficult in investigating complaints, just us basically getting the information. Also with complainants, sometimes they don't stay in contact with us as they should, and it's hard to get additional information that we may need for the investigation. We do conduct rebuttal interviews to give the complainant a chance to basically give us their side of the story. Once the respondent, if they have provided a response, we give them a chance to give us their side of the story as to what they feel happened or didn't happen. And then sometimes, as well as the rebuttal interview, if we can't contact the complainant for a first initial interview to basically determine the clarity of what they're claiming as their basis and what their complaint is. So sometimes those things can be difficult and cause us to, not be able to conduct a thorough investigation, I guess, as you will, and causes problems. Okay, once the investigators have received documentation from the respondent, They've requested additional information as far as comparative data. They've interviewed parties. They've interviewed any witnesses that may be involved in the case. The investigator sits down to determine which laws are at issue as far as the complaint. What is the specific legal allegation that they are claiming? And what are the facts that were found during the investigation? And that's basically done by using comparative data, looking at other files for other tenants, lease agreements, payment history, things like that. And then we also look at the legal rights and obligations of a respondent as far as fair housing. So as I mentioned, investigators, once they have concluded their investigation, they are responsible for conducting or developing a final investigative report, as well as a notice of finding. And this report basically details what the complaint alleges, what we found as far as the evidence, and then basically gives an explanation as to how we came to, or why we came to, a conclusion of either reasonable cause or no cause. So in no cause cases, the complainant has the right to file an appeal within 15 days of receiving that notice of complaint. If we find evidence of discrimination or a cause finding, there are 3 steps that can be taken within this cause finding. The parties can elect to either go to state court or could have it heard in front of an administrative law judge, which makes a determination as to whether the law was violated. We also have a ADR department who will also conduct pre-cause conciliations. And, if that's the case, then the case is a conciliation agreement is drafted and the parties sign the agreement and the case is administratively dismissed based on those reasons. Okay, Mackenzie, I think that was it for me.
With that, we're going to go ahead and move on to ICRC's Deputy Director, Tim Schultz. So we'll go ahead and turn it over to Tim. Thank you, Melissa.
Okay, great. Thank you, Mackenzie. And thank you to everybody who's presented today and taken the time to do so. We do appreciate that, and I appreciate the opportunity to be here as well. So before I begin, similar disclaimer from what Melissa showed earlier, the ICRC, we don't make the law, we just enforce it. Anything I talk about today shouldn't be considered legal advice. If you do need legal advice, please contact an attorney. And then, of course, this presentation is intended to provide general information and guidelines, but shouldn't be considered official agency policy. So we've been talking a lot about fair housing laws, both federal and state today, and I'm going to try to give a very brief overview of what those laws are, how they work, and how they're applied. And so I'm talking about hundreds, if not thousands, of pages of statutes and regulations. So, of course, this is going to be very, a high level. I won't cover everything, but if you have questions, we'll try to answer those at the end of this. So what you're seeing there is the Indiana Fair Housing Code. And as it states, the intention is to ensure fair housing practices, allow for investigations of claims, and also provide remedies depending on the consequences or the results of those investigations. So why is it important to have a fair housing law? Well, the simple answer is that discrimination between individuals is lawful unless it's prohibited by law. So for example, think of an employer conducting interviews and they ultimately hire somebody with more experience or a higher education level. Well, technically that's a type of discrimination, but it's not unlawful to do so. Similar in a fair housing situation, if you're selling your home and you give preference to somebody paying cash versus somebody who's not, again, that is technically a type of discrimination, but it's not prohibited by law. So the fair housing laws, the Indiana Fair Housing Laws, protect people from discrimination for really all housing related activities. And that's why it's so important to have that law, is because without it, your remedies could be very limited if existent at all. So kind of the first question is who's subject to the fair housing laws and who can file a fair housing complaint? As you can see on the screen, sellers, landlords, leasing agents, those are kind of the individuals or entities that you would probably think of when you think who's subject to the fair housing laws. You might not always think about mortgage providers or homeowner associations or realtors, but they are potentially subject to those laws as well. And in fact, the law is silent as to who a complaint can be filed against. So it's a very broad category. And one thing we would always encourage anybody contacting our office with, or thinking about contacting our office regarding a fair housing claim, just be mindful that it's a very broad category, and you might be surprised who is subject to those laws. Similarly, who can file a fair housing claim? It's any aggrieved party, and that's someone who can show that they've been injured by discriminatory housing practice. And again, that's an incredibly broad category of individuals. The Discriminatory Act doesn't have to be directed at you. As long as you're impacted by it, you're injured by it, you've experienced it, you can still possibly file a complaint with us, and that will be investigated, and potentially a cause finding might result in litigation. Interestingly, you don't even technically have to be interested in the housing to be able to file a complaint. A good example would be testers. There's fair housing testing that goes on nationwide, including here in Indiana, and those individuals have standing to file a complaint, even though technically they're not trying to actually get housing. And I'll talk about that program a little bit more at the end. But I think I just wanted to illustrate the point that it's who is subject to the laws and who can take advantage of the laws it's incredibly broad on both sides. And we always like to make sure people understand that they might have rights they don't realize they do. So common forms of discrimination, housing discrimination, usually takes one of two forms, disparate treatment or disparate impact. And disparate treatment is probably what when you think about discrimination, that's what you're thinking about. That's when a housing provider treats people in a protected class differently than others not in that class. So for example, a rental facility says we charge Catholics $400, but we charge non-Catholics $800 at rent. Well, it's pretty obvious that's you're treating individuals that are protected class differently, and it's relatively straightforward. The other type of discrimination, disparate impact, that's when a housing provider employs a facially neutral rule or policy that results in different outcomes. And this is usually a much more complex type of discrimination to investigate. And this is where you're focusing on outcomes. So for example, a housing provider might have a rule that applies to everyone, so no pets allowed. Just everybody's treated exactly the same, the requirements apply to everybody. But what's the outcome of that policy? Even regardless of the intent, the outcome is that individuals with disabilities who have service animals are going to be or receive a disparate impact from that kind of a policy. And that's a very simple type of example. Like it can, of course, be much more complex and nuanced, but those are the different types of discrimination that you commonly see in fair housing. So the next question is, well, when can fair housing discrimination occur? And the answer is pretty much any time. It can happen before the sale or the tenancy, or during, or even after. So I'm going to very briefly explain some examples from those three categories. Because our time is limited, I won't spend too much time talking about these, but of course, if there's any follow-up questions, please let me know. So common types of discrimination you might see before the sale or tenancy is refusal to sell or rent or deal. And I do want to stop there just to note that it doesn't have to be a outright denial to do one of those things. Delay tactics are a type of possible discrimination. So the housing provider might not say, I'm not going to sell you this house, but if they delay in your attempts to purchase the house or a rental, that could be a form of discrimination and possibly, a refusal to sell situation. false representations about availability, that's or steering. That's when basically you're pushing individuals towards maybe a particular zip code or neighborhood, or just saying something's not available when it really is. Again, that's something to be mindful of, and it's likely a type of housing discrimination. During tenancy or home ownership, that's very terms and conditions. So, for example, if the landlord consistently takes more time to fix maintenance issues for individuals in a protected class versus other individuals, well, that's an example of possible discriminatory practice. Coercion, intimidation, threats, interference. I think a good example of this would be an individual who asks for a reasonable accommodation. So they say, well, you have a no pet policy, but I'd like to have my service animal in my home. And just by making that request, the landlord responds by threatening to evict you. Well, of course, that's certainly intimidating and threatening by simply making a reasonable accommodation request, which, of course, individuals are allowed to do. And then after tenancy, here's an example of, I kind of using the example I just used about making a reasonable accommodation request. So in that situation, rather than threatening to evict them, you simply just don't renew their lease at the end of the lease. Or retaliation. That's a really simple example would be you file a complaint with the Indiana Civil Rights Commission, and in response, the landlord evicts you. That's by law, that's not permitted. There are certain protections that we do enforce in that type of a situation. But those are the three times, well, the times when fair housing discrimination may occur. As you can see, it's the timeline is really any time before, during, after. So I did want to take a few moments and talk about some recent developments and that we've been monitoring or researching here at the Indiana Civil Rights Commission. And as you can see, COVID-19 and fair housing, probably no surprise there. I did want to spend a little bit of time talking about discriminatory statements in advertising. And then, of course, our testing program, our fair housing testing program, which I mentioned at the beginning of the presentation. So the first thing I think we would tell anybody is that despite the presence of COVID-19, fair housing laws still apply. And that's the most straightforward statement I can make, is that certainly things have changed, but the laws are still enforced and in effect, and we still investigate them as we always have. Something that comes up rather often is, what are the appropriate steps for housing providers to take if they find out that somebody has, been diagnosed with COVID-19 in their property? The thing you probably want to avoid is identifying that individual and letting everybody in the housing property know that that individual has gotten that type of diagnosis. You're probably going to run into some trouble there. But that doesn't necessarily prohibit a housing provider from saying that there's been confirmed cases of COVID-19 in their property and informing all everyone in the property in the same fashion with the same information without identifying any specific individuals or locations. And then, of course, increased discrimination complaints pertain to certain protected classes. I think that an easy example is familial status. So having children who are under 18 years of age, there can be a perception that children may be more likely to have that particular illness or spread that. And, a housing provider might, say like, well, we're going to limit our new rentals to individuals who don't have kids because we want to protect our residents. That's I think a good example of a policy that it's intended to be benevolent and protect individuals, but the result, of course, is that you're discriminating against individuals with children. And then another issue that's we've seen and investigated is the idea or the concept that how do you handle reasonable modification and accommodation requests when you've got, public health crisis going on. And under normal circumstances, an individual with, let's say, an individual with disabilities who might use the gym at a that's available on a property for therapy. They need to do some sort of exercise that's part of their physical therapy. And of course, then these days that facility might be closed, but that individual then asks the landlord, well, can I access that so I can continue my therapy? And this is just a very good example of how each of one of these requests is a case-by-case analysis. So often it's hard to compare one case to another because everything turns on the facts. For a situation like that, the review of that request, the consideration of that question or that request, and of course, the verification and consideration, the landlord might ultimately determine that, well, there is a direct threat that results from that accommodation request, and it might be appropriate to deny it because an accommodation is not reasonable if it causes a direct threat. Now, please don't just assume that situation or any situation like it would be a direct threat. I use that as an example. And again, it's always fact sensitive, and every request should be treated as an individual analysis. So, discriminatory statements in advertising. These are statements, this occurs when a statement is made in writing or orally that indicates any preference, limitation, or discrimination. This is found in both the state and federal laws for fair housing. And the standard for determining whether a statement or advertisement is potentially unlawful is the ordinary listener standard. Basically, the inquiry is whether the alleged statement would suggest to an ordinary listener that a person of a protected class is preferred or disfavored. This is something that, of course, it's not a recent development, as the title would suggest on that slide, but it's something that has gained new attention given what's been going on for the last year or so, because these types of statements are possibly more common with individuals focusing on safety and concerns. So like what I was saying before, that idea that well, we're going to advertise our rental units, but we're going to say that there's no children allowed because we want to, ensure that everybody's staying safe and healthy. That's probably an example of a discriminatory statement or advertisement. And the interesting thing about discriminatory statements in advertising is that although certain entities may be exempt from the fair housing laws, certain religious organizations or private organizations or individuals who might only have one property for sale or rental may be exempt from the fair housing laws depending on their circumstances. But if you advertise or make discriminatory statements, such as I'm selling my house, and I tell somebody that, well, I won't sell my house to a woman. Well, despite the fact that under normal circumstances, you're exempt from the fair housing laws, such a statement would apply and would allow an individual to file a complaint, and that seller may find themselves subject to the fair housing laws, even though under normal circumstances they're exempt. But it's so important that individuals are aware of this type or this requirement, because obviously indicating, even like I said, orally, a preference to maybe not have a particular national origin. Client renting at your facility or buying your homes, that's going to cause some possible issues, and you might not realize just saying something like, well, I heard kids are more likely to spread COVID-19 to an individual might be just considered discriminatory. So it's just and the intent doesn't matter. It doesn't matter if your intent is to keep everybody safe and healthy, or if you're intending to actively discriminate. The intent of those statements is not relevant. What's relevant is the impact it has on the ordinary listener. Now, what's interesting, there's a small caveat here. you, based on a 2012 Ninth Circuit decision, you probably can specify certain things in advertisements and statements for a roommate that you would not be able to do under other circumstances when you're renting or selling a dwelling. Under that federal circuit decision, it's actually, they did permit the individual for putting an ad up requesting a roommate, and I think the requirements was that be a female Christian. And ultimately they said that was permissible because, I'm giving a very short summary, but the intent was not to have the Fair Housing Act in like where you sleep. It's not intended to tell you who you actually have in your room with you. It's who you can sell and rent and how you conduct other housing activities. But there basically is a roommate exception. Now, that issue has not been considered by Indiana state courts or the Seventh Circuit, so we don't know exactly how that would turn out. But there is HUD guidance out there that is more or less in line with that decision, so it seems quite possible that that exception would be applied here in Indiana. And then finally, I wanted to briefly discuss the agency testing program. We as an agency have the authority to one conduct fair housing testing, and then based on those results, create what we call director-initiated complaints, which is that's pretty much is what it sounds like. A complaint is created in the name of the executive director of the agency based off the results of that testing. And this is something that we have done in the past and we are continuing to do now. In fact, I think we have somewhere between 10 and 20 active complaints or complaints that are being drafted based on that program. And the results, of course, can vary, but there are certain settlement options that might be obtained that make sure that the individuals who live at that housing complex are basically informed of their rights, their fair housing rights. But that is something that we continue to do, and we're actually getting ready to do a new series of fair housing tests that are actually focusing on COVID-19 issues. So we're excited for that program, and we think it's a good way to ensure that anybody who's subject to the laws understand those laws and comply with those fair housing laws. And that is it for me. I know I went a little bit over, but I hope everybody appreciated the information.
Thank you, Tim. And I think we're actually pretty close on time, so we can go ahead and I'm going to open up the Q&A session. Has the pandemic increased the need for affordable housing, and how is affordability determined?
Yes, so yeah, the pandemic definitely has increased the need for affordable housing. We have had a steady increase over the years, but with the pandemic, a lot of people had their jobs were affected. Either they lost their jobs, companies have flat out closed. They didn't have any sort of plan after the fact. And just with the pandemic, nobody was financially prepared for that type of event to occur. So it definitely affected a lot of individuals, which created an additional need for affordable housing. So all of our housing programs, for the most part, are income-based. So there is income limits that we have established by HUD each year, and that's what we go by in determining if we can help a household or not. But obviously, since a lot of individuals who may have not needed affordable housing at the time, but they probably do now. So I hope that addresses that question.
Does ICRC and HUD always dual file the cases, or do you contact both of them or just one?
All right, Mackenzie, I think I could answer that one for her. So how it works is you don't need to contact both of our agencies. So if the issue is something that's jurisdictional to both the federal Fair Housing Agency or HUD and the state or local FAP. Then if you file with either one, we're going to dual file with our respective partner. So for example, if someone were to come to HUD and want to file a housing complaint, and that complaint was jurisdictional under Indiana's law that Melissa and Tim explained, what we would do is we would dual file that under both the Fair Housing Act as well as the Indiana law, and then that case would be referred to the ICRC for investigation. So you don't need to file with both entities as long as it's jurisdictional with both entities. Now, there may be situations which come up because you may have a situation where a situation is covered under, for example, the state or local law, but it's not covered under the federal law. I think Melissa had indicated that there are additional additional protections under the state law that's not under the federal law. Under those circumstances, those complaints would have to be filed with the state or local entity if it's one of those bases that's not covered by federal law. What we typically do at HUD when we get a complaint like that that's not jurisdictional for us, we would refer the individual over to the Indiana Civil Rights Commission for instances. Now, with anything, there are some exceptions where in our MOU, we may ask that our state or local partner waive a case back to us, in which case then we would undergo the investigation in those circumstances. So for example, if it involves a situation of, let's say, a systemic discrimination or a pattern in practice, HUD may request that we keep one of those cases, and those cases wouldn't get referred over to our FAP partner. So I think that answers the question. So the other aspect of it would be if you file directly with ICRC, what they're going to do is they're going to dual file it with HUD, but the case will still remain with ICRC for investigation, but it'll be processed under both the Fair Housing Act and the state law.
Okay, perfect. Thank you, Lon. I appreciate that. And I remember this next one came in while Melissa was speaking, and it's focused on investigation. So this one might be your response, but it says, who makes the final determination on whether there is a cause finding or not in the investigation process?
Okay, yes, I can answer that. So the investigators actually make a recommendation. The final determination is either made by our Deputy Director, Timothy Schultz, or our Executive Director, Gregory Wilson.
Okay, perfect. Thank you. And then someone asked, what are the most common remedies for housing complaints? Does the mediation occur frequently with the housing complaints?
I can try to answer that one. This is
Okay.
Tim. So I'd say the most common remedies that you see for fair housing mediation takes one of three forms, or could include all three. So there's usually a training component where either the landlord or the property management company might be required to take fair housing training, which we provide. I think another component is there's often a financial component, maybe reimbursement of rentals or some dollar amount. And then I think the third most common type of remedy you might see would be some form of accommodation, either or accommodation or modification. So, for example, allowing a service animal to be on the property, or building a ramp to allow a wheelchair ramp at a particular property. I'd say those are the most common types of remedies that we see from our mediations. And as far as the frequency, I couldn't tell you off the top of my head how many of our investigations and litigation fair housing cases are mediated, but I think it's fair to say most have some form of mediation at one point or another. It might not be successful and the matter might continue on, but I think a lot of parties are usually interested in at least trying to see if there's an informal resolution.
Okay, thank you so much. Let's see, the next one is, how could the pandemic relate to a protected class in housing, and would it be considered a disability?
Well, I think it could be a couple different, I guess, protected bases. It could be national origin, because some individuals perceive those individuals who are of a certain national origin as being the culprits of COVID-19 and passing that, disease along. And then also the disability basis where individuals who are maybe in nursing homes or who have certain disabilities could be perceived as being those who could possibly transmit it to others within the community.
Okay, thank you. And then we just have a comment that someone wasn't aware that the realtors were classified in the fair housing. And then someone else asked, if a realtor refuses to show a house to a new potential client and they feel that it's due to the low pre-approval amounts, how would that be proven in the investigation process?
So, Melissa, you might have something to add to this, but I was just going to mention that obviously we have to be very mindful that we can't address hypotheticals or situations that individuals have maybe personally experienced. But generally speaking, Melissa, I'll turn it over to you for more detail. That would be, I think, wouldn't be proven. I mean, we investigated through our traditional techniques of conducting interviews and gathering records, so we can request records from both the respondent, the complainant, and we actually also have the authority to issue subpoenas for documentation. So, but that's not specific to that situation. I mean, that's how we conduct most of our investigations. But Melissa, is there anything you want to add to the investigation process?
No, I think pretty much that covers it. Like you said, all of our investigations are basically conducted by gathering evidence and looking at comparator evidence. So we're looking at, policies and procedures. Did they follow those policies and procedures? Other people who attempted to look at properties, were they shown properties? What was the reason given for not showing? So there's different aspects of the investigation that we look at. And like Tim said, there's really no way to say this is how you prove a case or not prove a case. It's just basically having documentation and,
And if I may, Melissa, because you just ended on documentation, that's something we really always try to encourage individuals to be aware of, that documentation is just so incredibly important to a fair housing complaint. I think somebody mentioned, reading your lease, having a copy of your lease, having a copy of any particular policy, which was the subject of your complaint that the housing provider might provide. Documenting any communications you have with the housing provider. That's incredibly important. That's probably the first thing that the investigators are going to ask about, and having that information is very likely to ensure a very robust investigation that looks at the matter that's subject to the complaint.
Okay, perfect. Thank you. And then as of right now, we just have one more question left, and it's kind of, I think, along the same lines after reading it. It's in regards to like a description of a housing, making comments about families. So when realtors use great family home or great school district for your little ones, is that considered discriminatory? Or when, basically, I think is what they're asking is when it's related to housing as or family as the protected class in housing, is it for those who only have families, or in regards to those who don't? If the posting relates to family friendly, or if it says perfect bachelor pad, basically around those lines, I think is what they're saying.
I would say this, and again, this is just general guidelines. Any kind of statements or advertising that identify protected classes and state a preference or disfavor for that protected class is possibly going to result in a violation of fair housing. Every situation is different. Every investigation is unique. But I think those general guidelines are something to be mindful of. And if you, and a lot of times that stuff happens because people just don't even think about it. It's not that there is an intent to discriminate. it's just people aren't educated on the laws and they don't understand that something like that might be considered discriminatory under Indiana's fair housing laws. I don't know if Melissa, you want to add anything to that?
No, I think that about covers it.
Okay, perfect. And then we just have one more come through. And I think we kind of touched on this a little bit ago. It says, is COVID considered a disability?
I mean, I think all we can say is it depends. Disability, the statutory definition escapes me, but more or less it means that some major life activity has been impacted. So of course that can be a very broad definition, and it just depends. And if you ever have concerns that you think you might be treated as having a disability and improperly discriminated against, and it relates to disability or disease, contact our office.
Tim, I also wanted to add, and correct me if I'm wrong, but in terms of what's considered a disability, I think the topic when you're discussing on if something is considered a disability is how long. So if it's a prolonged situation, that would determine, that's part of the definition of a disability, is the extent of how long and the effect that it has.
Yes. Yeah.
All right. Perfect.
Yeah.
Thank you.
And can I add just one thing to those two answers as well? As far as we're concerned at HUD, we're treating COVID like anyone else who's alleging a claim based on disability. So we're going to investigate whether the condition constitutes a disability just like we would any other condition. So as Tim and Melissa kind of referred to, disability is a defined term in the law. And so if anyone believes that they are discriminated against because of the fact that they had COVID-19 or a history of COVID-19, or if they're being perceived of having the condition, then they could certainly contact our intake unit, and we're going to go ahead and treat that just like any other alleged claim for disability, and we're going to evaluate that on a case-by-case basis like we would any other condition.
Okay, perfect. Thank you so much.
Well, this is Greg Wilson, Executive Director. I just want to say that if anyone listening have any questions or concerns, you can still call our office. You can contact it as 317-232-2600. We always will be glad to answer any questions that you might have that maybe you didn't want to speak to here on the panel discussion, but we're always available, and our office is open for walk-ins. So please don't hesitate to visit us and have those discussions with us. Thank you.
Thank you, Greg. And again, thank you to all of our presenters, Lon, Tim, Devin, and Melissa. Thank you so much for being here today and taking the time out to help put out some of this information to the public. And thank you to everyone who attended. Everyone enjoy the rest of your Monday.